Hey everybody, this is Deb with Truthification Chronicles, and we're going to talk today about the Supreme Court because they are back in session. Yep, they just started this week, so I thought I'd kind of catch you up on what they're doing. Plus, some of what they're dealing with actually kind of touches on the whole White House letter to, the Democrats and the idea of due process that Trump right now is being robbed of if they're going to call this an impeachment inquiry. Okay, so let's just start first of all with the Supreme Court. And here they have, these are their argument days, the ones in red. They had one on the 7th and one on the 8th, and then they've got a couple coming up next week. And then, they have these like conference days and everything. So, people think when they see this schedule, they think, well, they're not doing very much. They don't work very often. Well, they're doing a lot behind the scenes because there's an awful lot of reading and studying that has to go on. And, sometimes when I read through their transcripts, I'm just like, wow, these people really know their stuff. I may not agree with how some of the Supreme Court justices decide, but I do respect them for knowing their trade. Like I said, I may not agree with their specific arguments, but anyway, these were the oral arguments for this week, and we started out on Monday. There were 3 of them that they heard. And remember, with each one of these, there's not just the argument they have to listen to, which usually lasts about an hour or so long, but there's also all of the reading, because usually there's like 100 pages worth of, filings that go along with it. So there's a lot that happens. And one of the nice things about this is you can kind of find out real quick. See, if you go to this question mark here, this gives you a basic overview of what the question is that they're dealing with. And so the question that's presented in this one was, this was on Monday. Do the 8th and 14th Amendments permit a state to abolish the insanity defense? Wouldn't that be interesting if you can't, plead insanity? Because frankly, folks, if you kill somebody and you say you're not guilty by reason of insanity, I just can't see that, because anybody who kills somebody really is dealing with insanity of some kind. So, if it's a temporary insanity or what, but I just could never see that as a legitimate excuse in any way. So, yeah, that's just an opinion. But anyway, you can go through, you can see them. This one is longer, of course, some of them are. And this has to do with United States Patent and Trademark Office denies a patent application. The Patent Act gives the unsuccessful applicant 2 avenues for seeking judicial review. And so basically the question is whether the phrase all the expenses of the proceedings in this particular U.S. code encompasses the personnel expenses the USPTO incurs when its employees, including attorneys, defend the agency in Section 145 litigation. So that sounds like a real snoozer to me. I don't know. I'm not into patents and stuff. But this one's got a little bit of interest to it. This question is whether the 14th Amendment fully incorporates the 6th Amendment guarantee of a unanimous verdict. Okay, now, I read part of this, about half of the oral transcripts. They didn't have the oral audio up yet, but the oral transcript was there. And yeah, it brings up some very interesting questions. The 14th Amendment and the 6th Amendment, we're going to look at those two because in some ways they actually are touching on what's going on with President Trump, because they have to deal with how people go through due process and if they are, fairly treated in our legal system. So, and we know right now it appears President Trump is not being treated very well in our legal system. But anyway, here was the one that I read. Evangelisto Ramos was the petitioner, and it was against the state of Louisiana. As I understand it, from what I've read, like the first half of the case, the oral arguments here. It appears that the petitioner was upset because Louisiana has a law that says that you do not have to have a unanimous consent of guilt or innocence in a jury trial. Now, I didn't know this. I thought it was standard that everybody, when they talked about jury trials, it was 12 people and it was always unanimous. But evidently that's not true. According to the Constitution, it appears that there really is no designation of how many people sit on the jury, and there's no stipulation about whether it's unanimous or not. That kind of boggled my mind a little bit, and I guess Louisiana must have a thing where you can have either a jury trial of 12 where you can get a 10-2 verdict and still be convicted, or you can get a 6-0 verdict. Now, they did a lot of debating about the odds. Now, if you're a mathematician, this would be interesting for you to figure out. They said, what are the odds? Which way is it better? Do you have better odds to go in to 12 and speak to 12 jury members with the possibility that you could have 2 of them dissent, but, it'd still be decided, for you? Or do you have to have 6-0 and it has to be unanimous? So I don't know which way it would be. I guess the reason the guy was complaining was because it was not unanimous. Evidently, that's what I picked up from, his lawyer's arguments. But I will tell you that the justices were very hard on this guy that was arguing for him. So I don't know. They didn't sound real thrilled. Well, let's just, give you a little overview here. The Sixth Amendment protects the right to a fair and speedy public trial by jury, including the rights to be notified of the accusations, to confront the accuser, to obtain witnesses, and to retain counsel. This is what Cipollone was complaining about in the White House letter that he sent to the Democrats, because they were not, making it public. They were doing things in secret. And it says the rights to be notified of the accusations. They don't really, President Trump doesn't really know what the accusations are because they keep changing them. Oh, he did this. Oh, he did that. Oh, he did that. I mean, every time you turn on the TV, it's like they've got something else that he did. It was the Russia thing for a while, and then that fizzled totally. So then they turned around to something else and something else. And they just got this whole list and they just keep going one after the other after the other. So, that's been something he's not really been notified of the accusations. And if they did it legitimately, that would be part of the document they would put together. So there would be legitimate, actual accusations. And then he should also have the ability to confront the accuser. That's an important part. If you can't confront your accuser, that's just not being fair. It's not a fair trial. And then you should also be able to obtain witnesses and to retain counsel. And both of those things are being denied right now. The White House counsel is not allowed to go in with these people. That's the reason Sondland didn't go in, because, they knew there was just not going to be a fair hearing. And the Republicans are being told not to ask questions. So, yeah, and the Republicans can't subpoena witnesses, on that side to testify. So it is not fair. If the Democrats would vote on it, then it could go into those proper channels and the minority would have some rights. But the reason they're not voting for it is because, first of all, they don't want to expose these people in these iffy districts to the possibility of them being ousted because they stood up for the impeachment. Okay? There are many of them that, won, but their district voted for Trump. And that puts them in a very, very difficult position. So they don't want to put their people in that position. So that's one thing. But even totally apart from that, you have the idea that if they do go through the proper channels, which is what the White House letter was really saying, go through the proper channels. If they go through the proper channels, though, then it's going to give rights to Trump, and it's going to allow his attorneys to be there every time they have a witness testifying. Then the White House counsel would be able to be there. And they also would be able, the Republicans would also be able to subpoena different people as well. Like they could subpoena Rudy Giuliani. Wouldn't that be fun? And by the way, yes, I heard that Lindsey Graham is going to bring in Rudy Giuliani. Boy, I want to hear that one. That's going to be good. Because I tend to think that Rudy Giuliani is going to be allowed, the Republicans will allow him to present all of the evidence that he's collected. Now, remember, Rudy Giuliani did his investigation actually back in 2016. I think he started like about the time of the election. So he was doing the investigation from then until 2018, and he finished in 2018. So he really was not doing more investigation because he already had all the material. So the good guys really do have it all. They do. It's just a matter of trying to get the American people to listen to him, which is one reason why it's just my theory that maybe Trump knew all along. Trump and the, 17th letter of the alphabet team, I think they knew all along that it would probably end up in impeachment. And if it didn't, it was going to be a lot of accusations and be a kind of false impeachment like it is right now, all these, inquiries. But the deal is, if it goes to impeachment, can you imagine what the trial will be like? It'll be like the O.J. Simpson trial. Somebody was mentioning that, and it's like, yes, that's exactly what it would be like. Everybody will be glued to their TV set. They will be watching this. And that is the perfect time to red pill everyone, because the truth will be out there. It'll be in a court of law. They'll be presenting all of this. So that is a possibility. And the Sixth Amendment supposedly allows us to have those rights. Well, here is the Sixth Amendment. This is the text of it, really. All of this right here, that's it. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So you do have the right to counsel. They've put it now together in the Miranda rights, just so people know this for sure. In case they didn't learn it in school, they now know that that's what they have. And that's it, really. It's very short. There's not much there. But anyway, so that's the Sixth Amendment. Then we need the 14th Amendment, because both of these play together. Now, the 14th Amendment is more complex. It actually deals with several different things. It defines citizenship, contains the Privileges or Immunities Clause, the Due Process Clause, the Equal Protection Clause, and deals with post-Civil War issues. So that was the purpose of it. That's when it was put into place. And so let me go to that one. Here it is. This one is longer, but let's take it a little bit at a time. Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay, can you see how many different things that really touches on? That one in and of itself has been important to a lot of things. And this is where, they talk about subject to the jurisdiction thereof really is a clause that rules out anybody who comes here illegally. Because if you come in illegally, then you are not subject to the jurisdiction of the laws. So, yeah. Anyway, well, you still are subject to them, but you did not follow them, so you're not under that. You are not under the jurisdiction yet because you're illegal. You're a citizen of another country. So anyway, that's part of it. But let me just go on. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. Yeah, this is before it was PC, right? But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in the state. Now, of course, it's been changed later on to include females. So just to let you know that. But when they're talking about this, it's very interesting that following the laws actually is important. You cannot have participated in rebellion or other crime. Interesting. So I don't understand how they can count illegals. But that's another story. Section 3, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as any executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Is that interesting or what? Yeah, kind of interesting there, that anybody who has taken that oath of service to the United States and to protect the Constitution, to support the Constitution, and then is guilty of insurrection or rebellion against the United States or giving aid to the enemies of the United States, they kind of give up their ability to do any of that. Yep, that's kind of interesting. But Congress may, by a vote of 2/3 of each house, remove such disability. Kind of wonder why they put that in, but anyway, Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned, but neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. I'm thinking that one was mostly for, after the Civil War. And then Section 5, the Congress shall have power to enforce by appropriate legislation the provisions of this article. Okay, so that is the 14th. Now, this article actually is kind of interesting, this Wikipedia article, because it goes through and it takes each section of it and it talks more about it. So if you're interested in that, you can read that. It's just that we need to remember as we're going through things that there really are some definite rules that our courts have to abide by because that's our legal system. Now, there are some that we abide by because it's tradition, and those can be changed. And that's what evidently they're arguing about this unanimous verdict. It seems to be that Louisiana, of course, believes that, it is up to the state to make that decision. And it was the person who evidently was convicted of something, and I didn't go back to find out what he was convicted of. But he was complaining that, it was not unanimous, I guess, because it was all about unanimous verdict. So that's what this one was about, and I thought it was interesting. It would be fun to see what happens there. And I just think it's also bringing to the forefront the idea of what it means when we're talking about due process. And especially when it comes to President Trump, he still is a citizen. He deserves due process. You can't take that away from an American citizen. That's what the Sixth Amendment says. So anyway, going on Tuesday, they heard these two, and they both have to do with similar things about discrimination against an employee because of sexual orientation, whether that constitutes prohibited employment discrimination because of sex. So, in other words, if you are genetically a man, but you claim to be a woman, you say you identify as a woman, then if somehow you're fired for being someone who identifies as a different gender, is that going to be something that fits under discrimination by sex? I don't know. It just boggles my mind when they do stuff like this. This one is very similar. It seems to be a similar thing, which I'm surprised that they would do two of them that are so similar. I mean, they did them on the same day. So maybe they kind of wanted, there's got to be something different about them. I don't know what they are without going into them and researching it. I just don't know what the difference is, but it's kind of interesting that they're both working about employment discrimination because of sex, and they're trying to get, one's sexual orientation on that. Yeah. And then, guess what? There was a third one. And yes, it's the same thing. So this is what really is strange to me, because I know they are very kind of stingy about who they choose, because they're, let's face it, they can only do so many cases. So they tend to pick and choose their cases very carefully. I think it's really odd that it appears that all three of these were the same basic thing. So I don't know. I don't know on this. But those were the ones that they did this week. Now, of course, they will have some next week, and for a while it'll be off and on, but you can always come here and you can find them on the Supreme Court website. It's just supremecourt.gov, and they do give you some really good resources here. You can keep track of when their argument days are, and it'll even tell you whether it's a conference day. Then if you want to find out, you can find the oral arguments here, usually the transcripts. The audio, I don't know when they're going to post it, but they haven't yet for the ones for this week. So I'm not sure on that. But the transcripts, I believe, are there. And if they're not, I noticed down here, when you click on, that's the docket. Here's this one right here's the transcript. So this is the docket filing. So when you click on that, it gives you this kind of stuff. Okay? So, which doesn't usually mean a lot to those of us who don't speak legalese. But anyway, so there you are. That's what they're working on right now. Be interesting to see what comes up, and you can always keep track of it here. You can even look for other case documents. I don't know if let's look at their calendar. Oh yeah, they have their calendar kind of set, and they always like this term is going to be called the October term 2019, but that will last until next year. Okay? I mean, they'll still be hearing those all the way through June, it looks like. No, wait, that's conference. Arguments. Arguments end in April. And then this is where they start to put together everything that they're going to release. So, those are the argument days. There are not very many of them if you look at it. If they do 3 a day, it's really not all that many cases. So, that's why I was really surprised that they had 3 of almost the same thing. I don't know. Maybe it helps them rule better or something if there's 3 that are the same. I just would think that they'd pick and choose differently. But then, I'm not them, and I know they know what they're talking about. They've got all these cases. They all know about all these different cases and stuff. So, yeah, it was interesting. And yes, Justice Ginsburg asked questions, and so she was there. And Kagan does a lot of talking. She really was very talkative in this one that I was reading. I haven't read the other ones, but I did hear, too, that Clarence Thomas was not there on the opening day. Now, I don't know if that means like he wasn't there on the first for that conference day or if he wasn't there on the opening day of arguments. So, don't know. That kind of worries me a little bit. I hope he's in good health and everything. But I kind of expect him, when Trump is reelected, I expect him to probably step down before Trump leaves so Trump can get a replacement for him. Not that there's anything wrong with him. I just see that he seems to be a little kind of tired of what he's doing. It seems like it. That he's tired of some of the kinds of cases they end up getting. I could be totally wrong on this, but that just seems to be what I notice when I see, his responses to things. And I have to say, he is one that rarely ever questions. I mean, hardly ever. And he actually asked a question last year. He asked a question. It was like, whoa, Thomas speaks. Because he really doesn't. But, yeah, I do kind of think that just because he's getting older, and I think he probably believes that this would be a good time to step down so a much younger person could come in and get a good, strong, young conservative in there. So we'll see what happens. That's just my guess that he probably will sometime before 2024 so he can be replaced. But who knows? Maybe he'll decide to hang in there and keep going. He's really very good, and I love reading, some of the stuff that he's written because he's done a few opinions that have been really insightful. So, it's all out there, folks. If you're interested in the Supreme Court, I'll leave all the links down below, and you can check them out yourself. But especially, get to know this Sixth Amendment, because I really think that people need to be aware that these are the rights we have. And we need to remember this is what makes us stand apart from a lot of other countries. That not every country has this. And this makes us very, very special. That we do have these rights that allow us to have more of a fair trial than in many places. So be aware of this. And when people talk to you about Trump and they say, well, he should just go along with them and he should participate and help them out and do whatever, they're asking. They're just asking for information or, people to testify. Point these out and say, well, no, wait a minute. This is due process. And President Trump may be the president, but he still is a citizen and he has the right to these things. So if it's going to be a trial, if it's, they're accusing him of something, then he has the right to this stuff. And that's what his lawyer was complaining about. So that's what I've got for you on this. Don't forget, keep sharing this, folks. It's still there. The problem is you can't search for it if you don't have the URL for it. So make sure, I'll put this down below. Make sure that you get it because we're kind of slowing down here, 10:47. And whew, it's already October, 9th? So yeah, long way to go. But we're trying. At least we're getting people to think about it. If nothing else, that's what's happening. So that's a good thing because, fairness. And this is what it's all about. That we need to remember that our country was built on trying to be fair to people and not railroading people just because you don't like them or you disagree with them or you think they did something wrong. So that's what I've got for you on this one. I want to thank you for stopping by, and I'll see y'all later.